Chapter 6. Forks in the Facts. If we were writing an introduction to legal reasoning, or worse still, a book on legal theory, we would now devote a lengthy section to explaining the difference between what we are calling forks in the law and what we want to discuss next, forks in the facts. As we have explained, our legal system has so many different sources of law, statutes, vs. common law, multiple jurisdictions, conflicting precedents, etc., that it's often very hard to tell from consulting available legal materials exactly what the law is. Moreover, even when you have only one statute or case to rely on, there are typically a number of plausible interpretations available. Once again, then, it's not clear what the law is. Exam questions that force you into discussions of different rules or interpretations are based on what we've been referring to as forks in the law. It will come as no surprise to you as a law student, however, that even when the plaintiff and defendant agree on the applicable law, and even on a particular interpretation of that law, plenty remains for the parties to argue about. A significant number indeed, we would guess a majority of actual legal disputes turn not on questions of what the law is, but on questions of how the law actually applies to a particular case. Both parties may agree, for example, that an anti-discrimination statute prohibits gender discrimination at places of public accommodation. But the owners of a private golf club may argue that their golf course is not a public place, while the woman who wants to play the course may vehemently disagree. We call such disputes about the application of law to particular situations forks in the facts. In this chapter, we will describe some of the reasons why you will encounter so many situations in which applying the law takes some creativity, and we will once again map out patterns of forks that appear in law practice and, above all, on law school exams. A. How law creates forks in the facts. Why categories matter. You can't begin to see why law school exams generate so many hard problems until you grasp the importance of categories to legal disputes. We'll start then with a simple vignette to contrast the difference between ordinary and legal conversations. Imagine you and a group of friends were gathered together thinking about where to go to lunch. One friend, Tony, says he's dying for a plate of pasta and suggests you head to an Italian place. Another friend, Spanky, says he's in the mood for a diner. A third friend, Solomon, offers a concrete suggestion. Why don't we go to Joe's place, he says. Joe's place, it turns out, is just around the corner. It has booths with red vinyl benches, jukeboxes at each booth, and red and white checkered tablecloths. It serves hamburgers, fries, malteds, and sandwiches, but the house specialties are various pasta dishes with delicious homemade sauce. The right half of the menu is printed in Italian, and pictures of Frank Sinatra and Joe DiMaggio are on the walls. If your friends are anything like ours, the suggestion of Joe's place will change the focus of attention away from the type of place and onto the particular restaurant. Both Tony and Spanky are likely now to think about whether they would be happy eating at Joe's. Solomon's suggestion might not do the trick. Tony might say he doesn't like the pasta dishes there. Spanky might say the sandwiches aren't up to snuff. This will be a concrete dispute about the quality of Joe's place. But it's unlikely Tony would say something like, I love the pasta at Joe's place, but I really wanted to go to an Italian restaurant, and it's not really Italian. If he did, everyone else would label him a stick in the mud. The same would be true if Spanky raved about Joe's yet resisted the selection because it's not really a diner. Unlike ordinary conversation, legal disputes like our debate over the meaning of vehicle often pair plaintiff and defendant arguing about things like whether Joe's place is really an Italian restaurant or really a diner. That's because the legal rules will often divide the world into categories, with one legal rule applying to one category and a different rule applying to a second category. Homeowners, for example, may owe a different level of duty to invitees than they do to trespassers. Suppose, however, that I see a dangerous situation on your property and enter, uninvited, to try to stop it. Let's say I fear your child will fall in a pool. If I'm hurt on the way in because I step in dangerous chemicals you have carelessly left on the ground, I might sue you to recover for my injuries. Ordinary people might argue simply about whether I made the right call about saving your kid. Was he really going to drown? Common law courts, however, may respond to this situation by attempting to determine whether, because I entered uninvited, I was really a trespasser, or because I had good reason to enter, whether my status was converted to that of an invitee. This kind of problem forms the core of countless legal disputes and of even more exam questions. Again, if this were a book on legal reasoning, we would provide a more detailed description of why the law tends to rely on categories. The simple explanation is that the very notion of the rule of law has a sequential component. People want the law to be established before the disputed conduct occurs. Lawmakers cannot imagine every situation that might occur and establish a rule for it in advance. But the law can group activities into broad categories and establish rules covering each. The categories help citizens see the rules as being in place prior to an actual dispute. Judges who appeal to the categories already in place appear to have less room for partial or biased conduct than those who are told simply to reach a fair result. In this book, we aren't interested in whether this simple defense of law's categories is persuasive. Many of your professors will devote time to discussion about whether the law's reliance on categories really achieves objectives like predictability and reduced bias. But virtually every lawyer will agree that the law uses categories extensively. What we want to explain is how such categories contribute to the forks in the facts that form the core of so many law school exam questions. In this chapter, we will illustrate a variety of ways in which laws are structured by category, and then we'll explain why it's often difficult to look at a particular set of facts and determine which category they fall into. 1. Rule vs. exception. There is perhaps no more common legal formulation than having a particular area of law governed by a basic rule, but then permitting exceptions that apply to certain less common situations. The general rule under the Commerce Clause is that a state cannot alter the flow of commerce in ways that favor its own citizens over those of other states. But there is an exception for those situations in which the state is acting as a market participant and not a market regulator. The general rule is that acceptance of an offer forms a valid contract at the time it is placed in the mail. But one exception makes acceptance of an offer under an option contract valid upon receipt, and another permits the party making the offer to say in the offer that acceptance is valid only on receipt. I must hear from you by Friday. The general rule is that the prosecution can't use evidence the police have discovered during a warrantless search. But there may be an exception if the evidence was in the officer's plain view at the time it was seized. The general rule is that there is no duty to rescue, but there is an exception if the person refusing to give aid somehow created the peril or otherwise has a special relationship to the victim. The general rule is that a landowner may exclude strangers from her property. But if the landowner invites the general public in, let's say, to gamble at a casino or shop at a mall, then the law may invoke an exception that requires the owner to admit people he doesn't want, let's say card counters or leafleteers. A standard exam technique is to generate a situation in which it remains unclear whether the general rule or the exception applies. If you consider the categories in our examples, it's easy to see how this can be done. It's often hard to say whether a particular offerer has opted out of the mailbox rule, whether a state is regulating or participating in a market, whether evidence really was in plain view, or whether the landowner's invitation to the public was sufficiently general to trigger the exception. Such problems make good exam questions. 2. Statutory boundaries. Terms in statutes very often constitute categories that determine whether the statute applies. Article Roman II of the Uniform Commercial Code, for example, applies to the sale of goods. Let's say you hire me to cater a party, and a dispute arises. If the code has desirable provisions from my point of view, I may argue that I have sold you food. Since food is a good, I'll contend the code applies. You'll argue that you hired catering services, and that the food was merely incidental. In that case, the code won't apply. Similarly, suppose I sell you a customer list. That's clearly a sale. But is it a good under the meaning of the code. Or, to reconsider another example we used earlier, statutes may prohibit discrimination in places of public accommodation. Yet it's often unclear whether a particular establishment fits the statutory definition. Is a country club a place of public accommodation? How about a community reading group that meets weekly at the home of one of the participants? There are few more common exam techniques than requiring you to read statutory language carefully to determine whether the facts at hand fall within or outside of the categories established by the statute. 3. Sequential categories. Many areas of law are organized based on a sequential chain of events. At some magic moment in the chain, events will have proceeded far enough that the law will shift the transaction from one category into another. In contract law, for example, buyer and seller may discuss the particulars that might form the basis of a contract between them. As long as the language is sufficiently conjectural, however, the law may characterize the conversation as preliminary negotiations. Once one party puts a sufficiently concrete proposal to the other, however, the law may characterize that proposal as an offer. If the other party accepts, a binding contract may be formed. In criminal law, we see a similar structure. A deranged individual can sit in his attic all day long plotting how to kill his wife. He can write his plans in his personal journal and draw pictures about how the crime might take place. All these activities the law might characterize as mere preparations. Once, however, the potential murderer engages in an overt act toward completion of the crime. Let's say putting poison into a bottle of champagne he knows his wife plans to drink next week. Then the law may characterize his activities as attempted murder. Writing facts that leave you in doubt about which side of the sequence you are on is another classic exam technique. 4. Crossing the line. The metaphor of proceeding step by step from one category into another is sufficiently powerful that even when the law divides conduct in ways that might not always be sequential, we still often talk about crossing a line. It may be that what distinguishes a preliminary inquiry, any chance you might sell your watch, from an offer, "I'd like to buy your watch," is the language chosen, rather than some magic moment in a sequential chain. Sexual harassment cases force courts to distinguish between harmless office flirting and impermissibly unwelcome advances. It may be the first or the 10th meeting between the supervisor and employee that includes the improper behavior. So courts will be judging not the chain of events, but the quality of the defendant's conduct to inquire whether any incident or the behavior as a whole went beyond the point of no return. But as the rhetoric suggests, although the court's inquiry is qualitative, what did the defendant do? It will often be portrayed as sequential. Did the defendant go too far? In this context, too, you can expect to find exam questions that ask you to spot issues like which side of the line the defendant's conduct is on. 5. Categories as elements of legal rules. Running the gauntlet. One of our favorite torts teachers has a basic rap, although he'd never call it that he gives early in the semester to help relieve exam anxiety. 4 words, he says, are all you need to make a good start on answering any torts question. Those 4 words are duty, breach, cause, and harm. This is good advice if you think about how virtually any tort suit will require the plaintiff to prove each of these 4 elements. But it's an even better strategy if you think about how to generalize the point. Many areas of the law require one party to prove several elements to make out a case. Criminal law, for example, often demands that the government prove all the elements of a crime. These might include intent, an overt act, and causation of the forbidden result. Adverse possession often requires that the purported adverse possessor prove that she has had actual possession of the disputed acreage, and that the possession be adverse or hostile, open and notorious, continuous, exclusive, and for the time period required by statute in the jurisdiction. Notice how the party with the burden of proof must satisfy each element to make out the case. So it doesn't matter if the government can show intent and harm if the defendant engages in no overt act. If I sit alone in my house wishing you die, and you drop dead of a heart attack, I've committed no crime. We call this kind of legal structure running the gauntlet to remind students that each element must be satisfied. This contrasts with a multi-factor analysis, which is more like a recipe for a vegetable stew. The absence of a particular ingredient won't spoil the dish, since it's the overall mix that's crucial. Nuisance law, where courts weigh all the surrounding circumstances, is a good example of a multi-factor stew. Now consider how wonderful gauntlet running is for exam writers. Your professor may view it as a personal challenge to see if she can write a question where there is doubt about each of the several elements of a particular doctrine. And take our word for it, she can. So when you find convoluted exam scenarios that occur on deserted islands, this is a mere byproduct of your professor taking a doctrine like adverse possession, an exam favorite, and testing her creativity. Can remote ocean locations really be possessed openly and notoriously? If boats come ashore every now and then, does this destroy exclusivity? If the marooned island dweller sticks to one side of the island, does she possess the whole thing? If the island dweller leaves on her boat for several weeks at a time, does this undermine her claim of continuous possession? As we'll explain further in Chapter 9, there's a tendency when you see an ambiguity in one part of the story is possession actual, to assume you have scoped out the whole question. But doctrines structured as a series of elements provide multiple opportunities for hard issues. Don't stop until you've run the gauntlet. 6. Open-ended or evaluative categories. Classic issue spotting exam questions get most of their mileage from what might be called borderline categories: preliminary negotiations vs. offer, flirting vs. harassment, residential vs. commercial lease. We would be remiss, however, if we failed to mention the many situations in which the law places an evaluative label or category on a party's behavior, and lawyers and hence students are expected to argue whether that evaluative label applies or not. Here, it's not so much whether one of two labels, offer vs. preliminary negotiations, is applicable A or B, but whether a single, more open-ended label governs at all, yes or no. Contract law often imposes an obligation to perform in good faith. So an exam scenario may expect you to characterize a party's action as in good faith or not. Tort law often imposes an obligation to act as a reasonable person. So an exam may expect you to argue about whether particular conduct was or was not reasonable. Nuisance law requires the plaintiff to show substantial harm. So, is the harm substantial? What you'll need to do on exam questions like this is to ask yourself which flaws in the question support a claim that the action was in good faith, that the behavior was reasonable, that the harm was substantial, and equally important, what flaws cut the other way. B. Why categories don't settle things. Sources of factual conflict and ambiguity. We imagine many of you reading the previous section have a nagging objection to the whole endeavor. Sure, you have learned in law school that the law divides things into categories, and that determining which category governs is often crucial to outcomes. But what you want to know is why figuring out which category applies is such a mystery. Why aren't the law's categories sufficiently determinative to permit you to ignore all this maybe business and to focus your energies instead on learning rules and routinely applying them to the facts? In this section, we hope to explain that despite the legal system's best efforts, doubts about proper categorization will be with us as long as we have law. We will detail many sources of that ambiguity so that you'll know how to look for them buried inside the complex fact patterns that make up your exams. 1. Facts on both sides of the category. Think back to our story about the Italian restaurant and the diner. Notice how we included facts that made Joe's place sound like a diner: booths, jukeboxes, malteds, and facts that made it sound Italian: wall photos, menu language, pasta dishes. This is an extraordinarily typical technique when drafting an exam question. The professor will take two well-established legal categories and write a story in which some facts point in one direction and some point in another. And we might add, the professors here are taking their cues from real life. There's just no reason to expect that actual events will occur along the precise lines of legal categories. Your job, then, is to see how the exam facts reflect ambiguity and make the arguments for one characterization as well as the other. In property, you might get a landlord-tenant question involving an unrenovated loft used as a music studio, where the outcome depends on whether the lease is governed by residential or commercial rules. The teenage musicians might actually be living there with the landlord's knowledge and tacit consent. He may have given them a key to the building for after-hours use denied to other tenants. But the building may be otherwise commercial, and the space may have no kitchen facilities. The heat may be turned off at midnight. Yet there might be a shower in the loft space. The lease might have the words commercial lease written at the top in big letters. In sum, there are facts that support the residential lease characterization and facts that suggest a commercial transaction. So you need to be prepared to argue either way. In contracts, your exam might contain a lengthy letter from a seller to a buyer. The letter begins, "We would consider an agreement on the following terms." This sounds like preliminary negotiations because the seller offers merely to consider an agreement. Yet the same letter may close, "It is vital that you let us know immediately whether these terms are acceptable to you, so we can begin our own procurement efforts." This sounds more like an offer. Since there are facts on both sides of the preliminary negotiations vs. offer line, you'll find yourself using the language to argue each way. Indeed, as we move to the following sections, you'll see that linguistic ambiguities are often a source of forks in the faux. 2. Differing standpoints. It may be that the facts are entirely clear, but they may look different from the standpoint of different actors. Suppose a supervisor is speaking with an employee who is active in union organizing and has recently gotten married. He says to her, "Congratulations in your position. It's a really good thing you got married." If the law prohibits threats made by employers, is this a threat? The supervisor may say he was merely trying to congratulate her on her good fortune. Yet the employee may see this as an implicit reference to her organizing activity. It's good she got married because she's going to need that income when she's out of a job. Or think back to Patron's offer to pay artiste $10,000 to paint a portrait, where the question was whether the preliminary sketch work was mere preparations or the beginning of performance. From Patron's perspective, the deal is for a portrait, and thus the fact that no paint has touched the final canvas may suggest performance has not begun. Yet artiste's understanding of what a portrait entails may lead her to conclude that doing the sketches is very much part of the process, maybe even the hardest part. Think about a paper you wrote for school, where you had done all the research and an outline, but hadn't actually begun writing. You would certainly say you had started the paper. Yet a professor demanding a 25-page paper might well give you 0 credit if that were all you submitted. So, even when the facts themselves are undisputed, the different perspectives of the parties may make it very unclear whether the facts fall in one legal category or another. 3. Differing time frames. The same set of facts may often be characterized very differently depending on how far back in time you go to evaluate the situation. The most striking example of this phenomenon we've ever seen was on a television news show. The reporter opened by describing an automobile accident in which a white driver seemingly driving at a safe speed and obeying all traffic laws ran down and killed an African-American pedestrian who was crossing the street on her way to work. Black faces in local taverns were then shown denouncing the death as a product of blatant racism. White faces in different bars appeared next to accuse the first group of finding racism everywhere, even in a simple traffic accident. Since there was absolutely no reason to believe the driver had acted wrongly or possessed any ill will, it was hard to imagine how racism could have had anything to do with the death. The story then switched, however, to how it was that the African-American pedestrian came to be in the middle of the street where she was killed. It turned out that she had taken the bus to work, and that she worked in a large suburban mall a good way down the road from the traffic accident. The bus did not stop in front of the mall, and the pedestrian crosswalk from the bus stop to the mall side of the street was, by all accounts, very dangerous. African Americans in the community had been lobbying for months to add a bus stop right in front of the mall to reduce the traffic risk. Their efforts had failed, however, and based on the television account, there was every reason to believe that powerful interests didn't want to make it too easy for African Americans to travel from the inner city to the suburban mall. The short time frame, focusing on the accident only, made racism appear an absurd charge. But the longer story created an entirely different impression. Manipulating time frames like this works for exam writers, as well as television journalists. In torts cases, there is a well-known rule exception structure, whereby one party has no duty to aid another, unless the potential rescuer somehow caused the victim's peril. Exam writers, then, will search for examples in which, at the moment of truth, the victim seems responsible for his own fate. So, a farmer might be strolling his grounds and hear a young child screaming from the bottom of a well into which the child has fallen. From a narrow time frame, this appears a classic case in which the farmer is under no legal duty to attempt a rescue, whatever his moral obligations. But the exam writer may also include facts that reveal the well to be on the farmer's property. It may be noticeably marked with a danger sign and as carefully shielded from accidents as is reasonable. Yet the farmer may have previously seen children too young to read or otherwise appreciate the danger playing nearby. This broader time frame suggests that maybe the farmer does have a duty to aid. Of course, on an exam your professor will want you to present the case both ways. Exam questions on self-defense in criminal law often make use of a similar structure. Where the murder victim has been terrorizing the defendant over a long period, the defendant may reasonably believe that the victim's latest conduct, e.g., picking up a bottle, threatened her life. But if we focus on the fatal incident alone, self-defense might appear a more difficult claim. Note, by the way, that differing time frames may help you to identify both a fork in the facts and a fork in the law in the same exam question. Thus, to continue our example, you may use time frames to discuss the application of a particular legal test, e.g., reasonable belief of imminent threat, to the facts. A short time frame suggests that defendant overreacted, whereas the longer time frame makes her self-defense claim seem far more reasonable. But you may also use the differing time frames to discuss the proper interpretation of the test itself. If we give imminent a plain meaning interpretation, defendant is in trouble. But if we look to the underlying purpose to sort out real from fancied threats, the longer time frame may support defendant's claim. We will have more to say about such twin forks in the next chapter. 1. Differing ways to make sense of the facts. A. Take things one at a time or view them as a totality. Imagine a contracts exam question in which one issue is whether an offer has been made. The alleged offerer has made the following statements. I'd really like to buy your watch. If I were to buy that watch, I'd probably pay around $300. And I have your $300 right here. It's pretty clear that none of these three statements, taken on its own, would constitute an offer to buy the watch. On the other hand, if you take all three together, perhaps an offer has been made. This kind of ambiguity obviously makes for a good exam question. One way to describe the ambiguity about whether the three statements count as an offer is as yet another kind of fork in the facts. Here, the clash is between seeing each of the statements in isolation and looking instead to the totality of the circumstances. You'll find the same clash in antitrust, where a set of allegedly anti-competitive practices might be viewed individually as just within bounds of the law, but collectively over the line. So two labor law cases might involve a set of anti-union management practices, where each one falls just within the legal limits. Yet the union argues that, taken together, they constitute an unfair labor practice. From a student's perspective, there may be a puzzle about why such forks in the facts exist. This is one of those cases in which our rulebook devotee might expect to encounter well-established rules settling such questions as whether multiple statements could or could not be combined into an offer. And as it turns out, sometimes there are rules on issues like this. In contract law, for example, The so-called modern view adopts a totality of the circumstances test for many interpretive questions. The presence of such a test will change the debate, but it won't make the one-at-a-time vs. taken together dispute disappear. Thus, a good lawyer and a successful law student would start an analysis of our watch hypothetical by acknowledging that the question presented is whether the statements constitute an offer in the totality of the circumstances. But there is still a fork in the facts. For one side will focus on the individual statements and emphasize their failure to add up to an offer totality, the sum of the statements, while the other side will argue that taken together the statements do indeed meet the legal test, the whole is greater than the sum of the parts. And of course, in some areas of the law, the well-settled rule desired by the rulebook devotee will give way to a murky divide between competing interpretations. The recent impeachment battle, for example, highlighted such an ambiguity in our understanding of perjury. Must perjury refer to a specific, i.e., isolated statement that is false and material, or can perjury be inferred from the totality of the witness's statements that as a whole are intended to mislead? The U.S. Senate was never required to resolve this ambiguity. But as a student taking exams, you'll want to watch for both forks in the law and forks in the flaws generated when the facts may be viewed in isolation or taken as a whole. B. Lenses of generality. As we described in the chapters on forks in the law, exam writers will often seize upon doubts over the meaning of rules by writing questions that hinge on stating a rule at varying levels of generality. An antitrust question about publication of a price list, for example, may be analyzed differently depending on whether the precedents are portrayed as broadly banning anti-competitive practices, which might include publishing a price list, or as narrowly prohibiting price fixing, in which case mere publication may be permitted. Sometimes, however, even when there is general agreement on the formulation of the rule, a similar ambiguity creeps down into what seems more like fact application. For example, many courts agree that one way in which tort plaintiffs can establish proximate cause is simply by showing that the defendant could foresee the plaintiff's harm. There is no need to show that the defendant could have predicted the precise set of facts giving rise to the harm. Yet virtually any exam question testing foreseeability will give you a chance to revisit this issue in determining whether the stated harm was foreseeable. Let's say the question asks about a landlord who fails to provide hot water. The tenant boils water on the stove to pour into the tub to bathe her child. As she carries the pot full of water, she slips and spills the water on her child, causing severe burns. Were the child's injuries proximately caused by the landlord's breach of the warranty of habitability? You can argue for the tenant by stressing that the accident is the kind of event the landlord should have expected might happen when residential tenants are forced to get by without hot water. On the landlord's side, your first instinct might be to suggest that the precise chain of events leading to the injury boiling, slipping, and spilling was too unusual for the landlord to foresee. But then you recall that proximate cause rules don't require that the landlord be able to foresee the precise chain of events. Don't give up. You can still make the causation argument for the landlord by remembering that there are many different levels of generality, not just two polar choices. The landlord's position isn't merely that the precise chain of events was unpredictable, but that the type of accident that occurred was not a foreseeable outcome for failing to provide hot water. So you might argue for the landlord that matters would be different if there were a snake bite that couldn't be cleaned properly. No one would predict a snake, yet everyone knows hot water is needed to clean injuries. In contrast, burns like the one this tenant suffered may simply be too remote a possibility to hold the landlord accountable. Or at least you could so argue on the landlord's behalf. To take a second example, a rule of law may distinguish between permissible puffing and unlawfully deceptive practices. A manufacturer can advertise a vitamin supplement as good for you, even if many objective observers might disagree. But commercials that tout the supplement for cancer prevention better have evidence to back up the claim. Notice how general claims sound more like puffing, whereas specific claims require greater levels of proof. Your exam writer may try to invent a fact pattern that falls between the two well-recognized examples. Suppose, for example, that the manufacturer advertises that the supplement is guaranteed to make you feel 10 years younger. In cases like this, the legal categories permissible puffing vs. unlawfully deceptive practices are little more than placeholders for factual judgments. So you'll need to argue the statement in and out of each category. 10 years younger sounds pretty specific, but claims about feelings may be too vague to be more than mere puffery. Paying careful attention to how facts can be presented through different lenses of generality, and thus be argued into different categories foreseeable or not. Puffing or deception is another trick for answering the issue spotter exam. C. Linguistic ambiguity. Our last example of forks in the facts should be the most familiar, since our chapters on forks in the lab devoted significant attention to the multiple sources of meaning for words appearing in cases and statutes. Words also make up the principal components of legal categories that rely on lay understandings, and of particular relevance here, words are the key part of every contract. Any of your exams can choose to highlight the ambiguity in everyday language as a way of seeking argument about which category best fits the facts. Your contracts exams in particular will require you to read language with great care to determine the nature and meaning of the parties' agreement or lack of agreement. In theory, debates over contractual terms could be described as a hybrid between forks in the law and forks in the facts. To illustrate the point, recall the famous case of Raffles v. Winchell House, where the parties used the same word, peerless, but meant different things because they were each referring to a different ship named Peerless. On the one hand, you could analyze this problem as we do here as a fork in the facts arising from linguistic ambiguity. If we look at what the parties said, they have an agreement and hence a contract. But if we look at what they meant, the case comes out the other way. But you could also analyze the problem as a fork in the law arising from the same ambiguity. If contract law focuses on outward manifestations, then there's a contract because the parties' manifestations were the same. But if contract law focuses on subjective intentions, then there's no contract because they meant different things. In this book, we aren't writing about theory, so there's no point in worrying about whether this ambiguity is better described as a fork in the law or a fork in the facts. Instead, just familiarize yourself with linguistic ambiguity as another source of issues you are likely to encounter on your exams. Borderline cases. Some legal categories simply track ordinary experience in ways giving rise to interesting issues when actual experience proves other than ordinary. When we studied criminal law, courts had different rules governing searches and seizures depending on where the search was conducted. Police were afforded far greater latitude to search automobiles than homes. The distinction was built on claims about differing expectations of privacy in the two settings. So our professor asked us what the rules were for searching a Winnebago, a large motor vehicle that people may live in. This was a perfect exam question, because it required knowledge of the two categories and discussion of the reasons for the divide that might help determine how to classify the borderline case. Similarly, property law often distinguishes between fixtures that stay with a house and chattels that the seller may take with him. The basement boiler is a fixture. The dining room table is a chattel. But what about the 2-ton hot tub that sits in the pool house next to the built-in pool? Words vs. actions. It's very common for there to be a difference between what people say and what they do. So why not write a question that emphasizes that difference? Let's say you have a probationary employee whose contract is very explicit that during her probationary period, she may be fired at any time for any reason. The contract further states that her probationary period will end after 6 months, unless the employer approves her for upgrade to regular status at an earlier time. During the 6-month period, the boss says nothing about an upgrade. But after 3 months, he buys her expensive new office furniture, orders her business cards, and has her name embossed on the door. In the 4th month, the boss gives her 3 new assignments that clearly will take until the end of the year to finish. And in the 5th month, he fires one of her colleagues and transfers all that work to her as well. When she receives an offer of secure employment from another firm, she declines, citing how safe she feels in her current post. If in the 6th month, the boss comes to her and says she's fired because her work is no good, does she have any claim for breach of contract? The words used suggest one result. For the contract established a 6-month probationary period, and the employer never actually said it was approving her for upgrade to regular employment status. But she will surely argue that her boss's actions tell a different story. Written vs. oral statements. To continue the theme of job security, consider the all too common case of an employer whose formal written policy makes clear that all employees are subject to termination at will. Yet, in an exam question, the company recruiter tells the employee that no one has been fired here in 20 years, and that a person like you can count on absolute job security, something you couldn't find anywhere else in the industry. When the exam question seeks a response to the employee's discharge, it's important to note the contrast between the written and oral statements and discuss which should take precedence and why. Literalism vs. reasonable expectations. Your exam question tells the story of a mortgage company that takes the following actions. The borrowers apply for a loan on a home and supply the company with detailed financial information. A thorough credit check is done. Then the mortgage company sends an appraiser to the home who tells the borrowers that appraisal will be done in a couple of days. 3 days later, the company faxes the borrower a letter spelling out the details of the loan agreement. The first line of the letter says, "Congratulations, your loan has been approved." The mortgage company's representative also calls the borrower's insurance company to make sure the home is properly insured. Then the mortgage company's attorney phones the borrower and asks when a closing date might be set. A date is chosen, and the borrower liquidates several mutual funds to have sufficient cash for the closing. A week later, the mortgage company calls the borrower and says the deal is off. It turns out that the appraised value of the home was $50,000 less than the $250,000 expected, and a close reading of the 3-page, single-spaced letter that the company had faxed reveals the following clause. This agreement is conditioned on all necessary repairs being completed and a formal valuation of the house being completed at $250,000. The mortgage company thinks this removes any issue of its liability. Your job on an exam that poses these facts would be to highlight the obvious conflict between a literal term hidden in the maze of fine print and the reasonable expectations of the borrower based on the opening sentence of the letter together with the mortgage company's other conduct. Multiple sources of meaning. Parties may use words in their contracts that have different meanings depending on what context you draw meaning from. A written contract for a dozen boxes of frozen hamburger rolls might mean 12 boxes, if you take the literal meaning, or 13 boxes, if the commercial custom of a baker's dozen is to be applied. One party may reply to another's offer to sell goods by saying, "I accept your gracious offer, but I'd like to talk to you a little more about the terms." If we read this comment through a lay understanding of terms, we may see mere continuing negotiations. But if we hold the speaker to the legal meaning, we may say that acceptance of an offer means that the parties have already concluded a contract. Of course, the best exam questions may pose a long fact pattern in which several of these different ways of looking at facts are all combined into one story. Now that you have learned how to spot them one at a time, the next challenge is how to tackle multiple ambiguities simultaneously.